Breaking news from Washington has quietly rewritten how laws are enforced across the United States, and most Americans are only beginning to understand what just happened. A sudden Supreme Court decision, issued without months of public hearings or televised arguments, is now reshaping how power moves through the legal system. While headlines may treat this as a technical ruling, its consequences reach far beyond legal theory. This decision is changing how authority is exercised in everyday life. At the heart of this ruling is a basic but powerful question. Who controls law enforcement when a law is challenged? Congress writes laws, presidents direct agencies, but enforcement determines whether those laws actually matter. For years, enforcement has often been interrupted by courts issuing broad nationwide orders. In many cases, a single federal judge could stop a law or policy from being enforced anywhere in the country, even if the lawsuit involved only a few people. Over time, this practice became routine. Supporters argued it was necessary to prevent harm while cases moved slowly through the courts. Critics warned it gave enormous power to individual judges who were never elected and never intended to oversee national policy. The Supreme Court's new decision directly confronts this tension. The majority made one thing clear. Federal courts exist to resolve specific disputes between parties, not to manage national enforcement policy. When judges issue orders that go far beyond the people actually before them, the court argued, they move from judging into governing. That distinction is not academic. It is central to how the Constitution separates power. Judges are deliberately insulated from politics. They do not face voters, campaigns, or elections. That independence protects fairness, but it also means their authority must be limited. According to the Supreme Court, nationwide enforcement decisions belong primarily to elected branches of government, not individual courtrooms. The dissenting justices strongly disagreed. They warned that narrowing judicial power could allow unlawful or harmful government actions to continue for long periods. From their perspective, nationwide court orders have often been the only effective way to protect large groups of people who lack the resources to file their own lawsuits. This disagreement reveals a deeper divide over how rights are best defended in modern America. What makes this ruling even more significant is how it was delivered. The court acted through its emergency process. Emergency decisions are reserved for moments when waiting could cause serious or irreversible harm. By acting quickly, the justices signaled that the existing enforcement framework had drifted too far from constitutional design. This was not about a single administration or a single policy. It was about restoring boundaries. The effects began almost immediately. Federal agencies that had been blocked nationwide started reviewing enforcement plans that had been frozen for years. Policies once stalled by a single ruling could now move forward in many regions. State governments began re-evaluating how they challenge federal authority and how they enforce their own laws. Legal strategies that dominated the last decade suddenly look outdated. For law enforcement agencies, the shift is especially important. Enforcement actions are now less vulnerable to being shut down nationwide by one judge. This may encourage more decisive enforcement in some areas, but it also introduces variation. The same law may be enforced aggressively in one region while remaining blocked in another. Businesses are already paying attention. Uniform nationwide pauses once provided predictability. Now, companies operating across multiple states may face different enforcement realities depending on geography. Compliance decisions become more complex. Legal risk increases. Planning becomes harder when the rules vary by region. For ordinary Americans, the consequences may not be obvious at first, but they are real. Laws affecting jobs, healthcare versus education, immigration, environmental standards, and voting may now be enforced differently depending on where someone lives. Two people subject to the same federal law could experience very different outcomes simply because of location. Supporters of the ruling argue this is a return to federalism. They believe states should have room to operate independently, and that courts should not impose uniformity through judicial shortcuts. In their view, if national consistency is required, Congress should clearly legislate it rather than relying on courts to fill the gaps. The majority opinion reflects this belief. Uneven enforcement, they argue, is not a failure of the system. It is a consequence of keeping power within its proper channels. If laws are unclear or harmful, the solution is political accountability, not expanded judicial authority. This ruling also changes incentives across government. Federal agencies may now act with greater confidence, knowing that one adverse ruling is less likely to shut down an entire program nationwide. States may test enforcement boundaries more aggressively. Advocacy groups may need to file multiple lawsuits instead of relying on one case to achieve national impact. Power has not disappeared, it has shifted. Lower courts now face a period of adjustment. Judges must craft remedies more narrowly and be cautious about issuing sweeping orders. Some will adapt carefully. Others may push limits, inviting rapid Supreme Court intervention. Conflicting rulings are likely, increasing pressure on appellate courts. Politically, accountability becomes harder to avoid. When courts step back, elections matter more. Policy outcomes become more directly tied to who controls Congress and the presidency. The majority views this as a return to democratic responsibility, where voters, not judges, decide national direction. Critics remain alarmed. They point to history, when courts stepped in to protect rights that legislatures refused to defend. They fear limiting judicial reach could leave vulnerable groups exposed. Whether those fears come true depends on how responsibly elected officials use the authority now returned to them. What is undeniable is that the Supreme Court decision marks a turning point. The tools that once allowed rapid nationwide judicial intervention are no longer guaranteed. Enforcement will be more regional, more contested, and more political. This is not just a legal update. It is a structural shift in how laws move from paper into real life. And as this new enforcement era begins, the real consequences are only starting to emerge. As the impact of this Supreme Court decision continues to unfold, the real transformation is becoming clearer. This ruling is not just changing courtroom procedure. It is reshaping how the entire system of enforcement functions, from federal agencies down to everyday interactions between citizens and the government. The consequences will not be immediate headlines. They will be lived experiences. One of the most significant effects is the rise of uneven enforcement across the country. Without automatic nationwide court orders, federal laws can now operate differently depending on geography. A policy blocked in one district may be fully enforced in another. Supporters argue this restores constitutional limits on judicial power. Critics warn it creates confusion and undermines the idea that federal law should mean the same thing everywhere. Federal agencies are already adjusting their behavior. In the past, the threat of a single nationwide injunction encouraged caution and delay. Entire programs could be frozen overnight. Now, agencies may move faster and enforce rules more aggressively, knowing that legal challenges may only apply to specific plaintiffs. This shift increases enforcement momentum, but it also raises uncertainty for individuals and businesses trying to understand what rules apply to them. State governments are responding just as quickly. Attorneys general, who once relied on nationwide injunctions, must now rethink their litigation strategies. Blocking a federal policy may require multiple lawsuits across different jurisdictions. At the same time, states defending controversial laws may feel emboldened to enforce them beyond limited court orders. This revives a more confrontational form of federalism. Advocacy organizations face a tougher landscape. Litigation was once a fast path to national impact. That path is now slower and more expensive. Instead of one lawsuit producing broad change, groups may need to file many cases in many courts. Large organizations with resources will adapt. Smaller groups may struggle, raising concerns about unequal access to justice. For ordinary Americans, the effects will appear gradually but decisively. Workplace rules, environmental protections, healthcare policies, immigration enforcement, and voting procedures may vary more sharply by region. Rights that once felt uniform may now feel conditional. Supporters see this as democratic accountability returning to elections. Critics see it as a dangerous fragmentation of legal protection. The ruling also places new pressure on Congress. For years, lawmakers relied on courts and agencies to manage difficult policy disputes. By narrowing judicial reach, the Supreme Court is effectively telling Congress to do its job more clearly. If lawmakers want consistent nationwide outcomes, they must write precise laws that leave less room for dispute. Ambiguity now carries real consequences. Lower courts are entering a period of recalibration. Judges must craft remedies carefully and avoid sweeping orders. Some will comply strictly, others may test boundaries. Conflicting rulings are likely, increasing the number of cases heading toward appellate courts and eventually back to the Supreme Court. Politically, accountability becomes more direct. When courts step back, voters can no longer blame judges for policy outcomes as easily. Enforcement now reflects who holds power in Congress and the executive branch. The majority believes this strengthens democracy by tying outcomes to elections. Critics worry it exposes rights to political swings. History complicates the debate. Courts have often protected rights when legislatures failed, especially during civil rights struggles. Limiting judicial power raises fears that progress could slow or reverse. Whether that happens depends on how responsibly elected officials act and how engaged the public remains. What this decision ultimately does is shift conflict rather than resolve it. Power moves away from individual judges and back into a system driven by legislation, enforcement, elections, and public pressure. That system is slower and messier, but closer to the Constitution's original design. As this new enforcement era takes shape, one reality is undeniable. The rules governing how laws are enforced in America have changed. The effects will not appear overnight, but they will shape authority, accountability, and daily life for years to come. This Supreme Court decision is not the end of the story. It is the beginning of a far more contested chapter in American law enforcement.